statements. So what I want to talk with you all about today is why you should care about the general stream adjudications. So let's start out with what are these cases? What are the Arizona surface water rights cases? I'm going to try to get my computer going so that we can get going. So this map shows the two areas that are covered by Arizona's two general stream adjudications. The darker blue color is part, does anyone, well, we won't, I won't ask everyone to volunteer. The darker blue area is the watershed that covers the Little Colorado River, which, as you all know, is one of the two major tributaries of the Colorado River that run through Arizona. And so all of the surface water claims, all of the claims of right to any surface water for any tributary, any stream that flows into the Little Colorado, all of those rights are at issue in the Little Colorado adjudication. The Gila River adjudication is covered or depicted by the lighter blue in this map. And you can see it's massive. It covers a huge part of Arizona. And think of all the rivers and streams that you know of that are in this area. Of course, it includes important rivers to people who care about wildlife habitat in Arizona, the Verde, the San Pedro, and all of the streams, all of the tributaries that flow into the Gila River, which, as you know, flows with its headwaters in New Mexico, and it flows all the way across Arizona and joins the Colorado River very close to Yuma. So let's focus for a minute on the Gila General Stream Adjudication. It was first filed about 42 years ago in 1974. That's when the adjudication commenced. There are almost 57,000 claims of right to surface water in this massive watershed that are at issue in the adjudication. There are over 32,000 parties in this adjudication. I guess I could take a moment to say, of course, some parties have multiple claims, so that's why you wouldn't have as many claimants as you have claims. These parties to the adjudication cover a huge range of different types of people and entities, from little individual claimants who are just trying to make sure that they have a right to their domestic water, to large cities, to the largest utilities in the state, to power, to mining companies, to small towns, to ranchers who need a lot of water for stock ponds, and ranchers who want a modest amount of water for stock ponds, comparatively modest. It includes Indian tribes. It includes federal claims for federally managed lands for which there is a claim of a surface water right attached. So this is a massive litigation with a massive amount of parties. And what is of most importance to us for this discussion today is that all of the surface water rights to the Verde and to the San Pedro and to other tributaries of the Gila River are at issue in this litigation. This litigation is really kind of a bottleneck for the state of Arizona in terms of our determination of how we are going to have enough water for our future needs, how much and where we get it. As you can just imagine, with all those claimants, with 32,000 claimants of every variety, we don't have context for people to do the kind of water planning that they need for the future. Because they don't know what their rights are, they don't know if they have rights they're claiming, and they don't know how much they have a right to. They don't know where they are in the priority land lineup in terms of surface water rights, and they don't know how much they actually have a right to. In the Department of Water Resources 2014 strategic vision, which is basically a roadmap to how Arizona will get the water it needs for the next century. It's a really robust document. I encourage everyone to go check it out. It's on the Department of Water Resources website. But in their strategic vision, the Department of Water Resources identified resolving the adjudications as the #1 priority. And the department put it very diplomatically, saying, while we have all this uncertainty regarding the nature and extent and priority of water rights, it's difficult to identify all the strategies necessary for meeting projected water demands. And that's correct, and that's diplomatic. In reality, while we have all this uncertainty, it is too easy for entities to avoid facing up to their own reality. And that's our problem. There are many, many entities that have not been sort of forced to reckon with whether or not they have the water for their future plans or even their current plans. Now, there's one big problem with the general stream adjudication, and this really is why this is very important to people who are thinking about protecting flows for habitat in Arizona. The big problem in the adjudication could be called, and is called by people in the adjudication, lawyers in the adjudication, the subflow issue or the subflow problem. Why should you care about the subflow problem? Well, often people who are involved in environmental conservation, we talk about and worry about the fact that groundwater and surface water are bifurcated in Arizona. And that means that there are two different systems for deciding what right you have to surface water or groundwater. And I think this is very familiar to most of the people here. But I'll summarize it really quickly. In Arizona, the right to surface water is established by the doctrine of prior appropriation, first in time, first in use. And that means essentially the first person who got there and claimed a right to water from a surface source, a river or a stream, gets that right. The next one down the line would be second in line, and so on. And when we talk about the adjudication to determine the nature and priority of all of the surface water rights, we're talking about the prior appropriation regime or doctrine. We're talking about taking all those 56,000 claims of surface water rights and essentially lining them up. And for each of those claims of right, attaching a quantity. The groundwater system, as I'm sure almost everyone on this webinar is familiar, is governed by a different doctrine, and that's the doctrine of beneficial use. And there are lots of rules about groundwater in Arizona, and Kathy will talk about the Groundwater Management Act, which is really makes a very different set of laws governing areas that are under the Groundwater Management Act. But with putting all that aside, essentially the right to pump groundwater is, if you are using the water for a beneficial use, then you can pump water out of a well on your land. That's in a very kind of simplistic but but accurate description of the groundwater system beneficial use at its core. Now, when Arizona adopted these two different regimes for surface water and groundwater, essentially we were ignoring the fact that surface water and groundwater are hydrologically connected. And when you put a well right next to a river and you pump like a maniac, eventually you may start to impact surface flows. In the Gila adjudication, this was an issue that was raised, and there was a lot of litigation about it, and it eventually went to the Arizona Supreme Court. And in a very important decision, the Arizona Supreme Court said, when water that is being pumped interferes with surface flows, then it's not groundwater, it's subsurface flow. And they said it's really important, essentially, to have recognition of this, of subflow, because otherwise we would have this problem of wells impacting surface flows. So the language that I have here on this slide is really the crucial, important language. The Supreme Court has said, we get it. Sometimes pumping groundwater interferes with flows, and in that case, that water is not being treated as, under our groundwater rules, it's treated as subflow. That's a really important decision, but the devil's in the details. What is subflow? How are we to determine what is subflow? The Supreme Court took a lot of expert evidence and looked at it, and then came out with this amazing Solomonic kind of determination that subflow is the saturated floodplain Holocene alluvium. Everybody knows what that means, I'm assuming, but just in case. The way I think of it is that what the Supreme Court was looking at are the layers, essentially layers, surface layers or layers of the earth laid down in different epochs, and the sort of rocky strata that was laid down during the Holocene epoch, which is a fairly recent epoch, that because of the geological history of Arizona, that is the strata to associate with the watershed's drainage. And so if you just look at what parts of that strata are saturated around a river, then you can determine that's the subflow zone. If it's wet and near the river and it's in the Holocene strata, it's subflow. Seems simple enough, right? All wells within this zone are subject to the adjudication because water pumped in that zone is potentially subflow. All wells in a cone of depression are also subflow, but the Supreme Court said de minimis wells, meaning they're pumping so little it doesn't matter, are not subflow. We'll just not worry about de minimis wells. This is quite a determination by the Supreme Court, and they uttered these important findings and then said, okay, DWR, just go out and map the subflow zones of all the tributaries of the Gila and the Gila as well. The decision was rendered in 2000. The DWR, for several reasons, and I hasten to say not at all DWR's fault, in my opinion, has not successfully had a single subflow map affirmed by the court. They have provided a subflow map of the upper San Pedro, and there have been years of litigation around that finding. And as you all know, DWR had its funding slashed in 2008. They lost a lot of staff, and it became much more challenging for DWR to complete this amazingly daunting work. So why should you care about the question of subflow? I have a case study or two for you about this. And first is, let's think about the upper and middle Verde watersheds and their future demand. And as we all know, a great deal of groundwater pumping is already occurring to serve the Verde Valley and other areas. And one of the contentions, not only in the adjudication but in other places, is that groundwater pumping is impacting flows in the Verde. The projected population for the upper and middle Verde watersheds is about close to 3 times what it was in the last census. The U.S. Geological Service has identified a supply gap potentially of 45,000 acre-feet for the Verde Valley subbasin, the Prescott Active Management Area, and the Big Chino subbasin put together. That's a huge amount of water, 45,000 acre-feet. If you think about the fact that the CAP delivers in a good year, when it gets its full allocation, 1.5 million acre-feet to serve about 85% of the population of Arizona. That gives you a little perspective. It's a very significant supply gap. I quickly threw in this slide to show projected base flow reductions on the Verde. These are also U.S. Geological Service projections, and these are projected reductions by the year 2109. I'm not sure why they chose that year, but it's like a century. The amounts given are the, as I understand it, I believe it's like a reduction from a century before by 2109. And these are very significant base flow reduction projections. But more significantly, I think we could think about the well drilling. The map on this slide shows the wells in the Verde Valley as of 1950. According to DWR data, there were 228 wells in the Verde Valley as of 1950. We go to 2011, and we have almost 6,500 wells, and these are wells that DWR knows about. And of course, it's very likely that there are wells that DWR doesn't know about, so the number is very likely much, much higher. This is the groundwater pumping pressure that the Verde River is experiencing. And I think everyone who's paid attention to the issues around the Verde River really understands that groundwater pumping is the existential threat to that river. The same is true in the upper San Pedro. According to the Department of Water Resources projections, the upper San Pedro will experience about a 50% increase in municipal demand. They project much larger demand overall. And these projections are by 2060. This is from the Department of Water Resources Strategic Vision document that I mentioned before. Probably many of you are aware of and I know Tricia Garrett, one of the plaintiffs in the case, is here on the webinar call. But you're aware of the litigation that is now in the Court of Appeals awaiting a decision. And this is a great example of the kind of issue that's going to arise as groundwater pumping continues to reach levels that are alleged to impact flows. So Cochise County is one of 2 counties in Arizona that adopted a requirement that new subdivisions demonstrate a 100-year supply of water before they could be permitted. And this was a sort of like special addition to the Groundwater Management Act that was enacted by the legislature in 2007. Kathy, sitting here, knows a lot more about it, so I'll leave it to her to talk more about it. But what I want to share with you is that the contention in this case, Silver versus Pueblo del Sol, is that a projected new subdivision in Sierra Vista that would be served by Pueblo del Sol Water Company through groundwater pumping would, because the water provided to this new subdivision would come from groundwater, the plaintiffs contended that that groundwater pumping was going to impair flows in the San Pedro, in the upper San Pedro. I won't belabor the details of the litigation, but the Department of Water Resources essentially said we're not allowed to take into account whether or not what is likely to be the very high priority and large surface water right of BLM for the upper San Pedro, for Sprinka. We're not allowed to take into account whether a new subdivision would impair that flow when we're deciding on the 100-year water supply requirement, because that right isn't adjudicated. We don't know how big it is. We don't know the nature and extent of it. Interestingly, in the trial court case, in that case, the lawyers were very open about their understanding that when the adjudication is finally resolved, it could well be that Pueblo del Sol would be found not to have a right to pump the water that it was relying on. In fact, the lawyer for Pueblo del Sol was asked about that, and he said, yeah, that could happen down the road. We could be found not to have that right. The lawyer for the Department of Water Resources said, we can always revoke the certificate. And we've only issued it to the date of build out of the subdivision. This is really not very consistent with the kind of water planning that most municipal water planners are comfortable with. But the lawyer for Pueblo del Sol essentially said, could we solve the problem? I'm going to quote him. Could we solve the problem by acquiring or buying hauled water, or could we dig a well 5 miles away? Yes, we could. Essentially, he said it's not an issue right now. Even if we're found not to have the water down the line, that's not for DWR to be thinking about now. So here's an example of where an economic development activity, the development of a new, very large subdivision, 7,000 homes for Sierra Vista, has really bumped up against the adjudication. So about a year ago, the Superior Court had some hearings and took some memos from parties kind of pondering how do we get this adjudication to move along faster. And in a really interesting order, the court said essentially, yes, the law regarding subflow is the problem. It may make sense from a philosophical perspective, but it's extremely difficult to apply in practice. And what I'd like to leave you all with is two things. One is, I hope that this is explained, and I hope you'll ask me questions if it hasn't, why the adjudication matters. If you care about flows in the San Pedro River or the Verde River, then the adjudication potentially will bring some certainty and clarity to what is now a very serious activity that's happening along those rivers and potentially impacting flows. If they're not impacting them today, and they may not be, they will impact them at some point if unchecked groundwater pumping persists. I think I said two things, and I guess the second thing is it may be that trying to litigate the general stream adjudication to its bitter end is not actually feasible, given the difficulty of every time DWR does a subflow hydrological survey to identify the subflow zone. I mean, so far we've had 14 years of litigation over the first one, and we're still waiting for it to be resolved, and we're far, far from it. So it may be that as people in Arizona who just care about good water stewardship practices and sound water management, we need to start thinking about whether there's a different way to resolve the general stream adjudications. And that's all I have. Now I'm going to turn to Kathy, and I guess Kathy and I have the pleasure of interviewing Kathy a little bit about the Groundwater Management Act, and then we'll have time, I think, Steve, you said, for questions. So Steve, I hope you'll ping us when it's time to go for questions. So Kathy, let me start by saying that a lot of people think of you as the architect of Arizona's Groundwater Management Act. I know that you were in high school at the time.
That's right.
But I wonder if you could just give us a little background about why Arizona decided to adopt the Groundwater Management Act, and give us a kind of overview of what the Groundwater Management Act does.
Well, that's probably like a full-day seminar, Sarah, so I'll try to say it in a couple of minutes, but hi everybody, by the way. You know, we've had problems with groundwater overuse in Arizona for a long, long time, and in the central part of the state they were perhaps the most severe because of a cotton boom and the fact that electricity was cheap and you could drill a well and just pump as much groundwater as you wanted, and there weren't any laws to regulate that. And it started to cause serious problems, controversy among different well owners, land subsidence, all kinds of things. But the legislature wasn't able to address the issue until the Arizona Supreme Court got involved in 1976 and ruled that a cotton farmer south of Tucson could stop the pumping and transportation of groundwater by several copper mines in the city of Tucson. Well, that was the impetus needed to get the legislature to take another look at this issue. And the result was the legislature established the Groundwater Management Study Commission. And I became the executive director of that commission almost by default. And the commission met for a long time, really tried hard to come up with solutions, but was unable to arrive at anything that agriculture could accept. Agriculture is the biggest user of water. Mm-hmm. And ultimately, finally, the Secretary of the Interior, Cecil Andrus, stepped in and said, if you don't pass a groundwater management law by the summer of 1980, then I'm going to stop funding for the Central Arizona Project. And that was the invitation to Bruce Babbitt to step in and mediate the negotiations among the major players that resulted in the Groundwater Management Act. It's a very nuanced piece of legislation, in part because it was drafted by committee. Mm-hmm. The mines and the cities and agriculture had to come to terms with each other's pumping and had to compromise really with what they each wanted for their respective group. So there are some key things about it. It applies just to the state's active management areas. These are areas of the state that are designated by statute. They cover most of central Arizona and also the Prescott area, and they involve about 83% of the state's population. And in the,
Kathy, was the intention in adopting those active management areas? What was it? Why those places?
The intention was those were the areas that were going to receive Central Arizona Project water. And so we knew that we had to include those areas in order to satisfy the Secretary.
We thought we would have the most growth in those areas?
Oh, absolutely. We thought we'd have the most growth. And that prediction has proven correct. But in those areas, there are a lot of things that happen, but no new agriculture, mandatory conservation requirements for all users. Wells have to be permitted. You can't drill a new well without a permit from the state. You have to measure your water use and file reports with the state every year. And really importantly, you have to show a 100-year assured water supply before you can build a new residential subdivision. So it was a landmark law at the time, and in my opinion, it still is probably one of the most aggressive laws in the country for managing groundwater. So the other big question for people here, and I'm pulling up a map of the groundwater management areas so that people can see it, but why should Arizonans care? And in particular, why should people who care about habitat conservation care about the Groundwater Management Act? Well, first of all, groundwater is a finite resource. Most of the groundwater we pump is never replenished, and so we're basically pumping fossil groundwater. And if we continue to pump at the kind of rates that we were pumping, at least in the active management areas, we would eventually run out. We have significant problems in other areas of the state where the Groundwater Management Act doesn't apply. And there's many reasons why Arizona should be concerned, apart from the fact that it's a finite resource. You know, in many parts of the active management areas, there used to be a connection between groundwater and surface water. But groundwater pumping for so many decades basically destroyed that connection. And so we saw the Santa Cruz dry up. We saw other rivers dry up. And now we have the chance to save, hopefully save, some other free-flowing rivers in the state, the Verde, the San Pedro. if we continue to allow groundwater pumping at the rate that it's been going on, those rivers will go the same way as some of the other rivers that we have. So it's an ecological thing, but also, you know, we're seeing with new farms that are pumping vast quantities of groundwater, we're seeing land disturbance and a creation of air quality problems. The Department of Transportation, in fact, had to shut down a freeway in the San Simon groundwater basin area because of all the dust that was being created by not putting land cover over between the rows of the new pecan trees that have been planted. So it creates land subsidence. It creates water quality degradation. I mean, it's just common sense to manage groundwater supplies, and we all need to care about it.
I just want to interrupt you guys really quick. If anyone on the line has any questions, if you guys could put those in the chat box there on the webinar side, we can get to those at the end.
Okay, that's great.
That's all. Thank you.
I was going to ask Kathy if there isn't, until there is management in areas that are not active management areas, there isn't any other way of getting a grip around groundwater pumping. But what is the solution? I mean, we have a few hot spots now. We have Wilcox, San Simon, La Paz County, where a big Verde has started.
And the Kingman area, the north.
And now Kingman, and I've heard that the growth in agriculture in far west Arizona near Kingman may be from farmers in California who are moving over out of concern for California's pending Groundwater Management Act. So moving into a state, at least an area of Arizona where there isn't groundwater management. But what do you think is the solution for these communities? Is it legislation that imposes statewide management, or is it more something local?
Well, so a couple of things people need to understand is that when the Groundwater Management Act was being written, we didn't just decide, well, we're going to exclude the rest of the state just because we wanted to. We actually went around, we had public hearings all around the state, and we were told pretty much uniformly by the rural areas of the state to leave them alone, that they didn't want to have their groundwater managed. Well, fast forward now 36 years, and we see all these really serious problems developing. And a lot of the water users in some of the areas you mentioned really would like to see some controls on groundwater pumping. Only the state can do that. The groundwater, people need to understand that groundwater is a public resource. It is not owned, despite what some people still think, it is not owned by the overlying landowner. It is a public resource that only the state may regulate. So in order to get some controls on how much groundwater can be pumped, there needs to be some state law that governs that pumping. Now, you could either, you know, you can create an AMA, you can create an irrigation non-expansion area, but most of those areas that are having these troubles these days are saying, well, we don't think those are the right tools. Well, so then they, working with the legislature, need to come up with the tools that would be acceptable to them, and the legislature needs to enact new laws to allow these tools to be put into place. And in fact, that's one of the things the Department of Water Resources is currently doing. They're holding public meetings in these areas and talking with the stakeholders there about what they would support. Would you support limitations on irrigated land? Would you support limitations on new wells? Would you support metering? Would you support a number of the things that are in the Groundwater Management Act? So it is yet to be determined what kind of traction will be garnered with those efforts, but ultimately local folks just can't impose it on themselves.
And so they need help. They need help from the whole state, from the legislature and the Department of Water Resources. So what if nothing happens? What will happen to, say, San Simon or Wilcox or the Kingman area?
Well, so I'm looking at the Department of Water Resources did a study of the Northwest basins where Kingman is located, and they've noted that most of the large-scale farming operations in the region are new, many of them less than 2 years old. So they don't even know yet what the impact of these new farms will be on the resources, but most certainly there will be effects on the groundwater supply from this vast increase of pumping. And, you know, I call it kind of the Californication of Arizona, because I think a lot of the farmers in the central basin of California were forced out of business because groundwater supplies became so deep they couldn't afford to pump them anymore.
Right.
So people will come here, more people will come here, more farms will go into existence, more exempt wells, small domestic wells will go dry. And, you know, we're seeing it in the San Simon subbasin too. As predicted, new lands are coming into cultivation. So, you know.
And now we have solar pumps, solar-powered pumps, making it a different business proposition, as I understand it.
Well, so, you know, here's the deal. I mean, you can either start now to get a grip on managing this supply so that you preserve it for the long term. Or you can just mine it completely away, and the economy blows away.
I noted that the Mojave County supervisors, they just passed a resolution requesting that DWR commence a formal study to designate, I think, the Wallapai Basin and INA, and irrigation non-extension area. And I noted that one of the supervisors said it was a choice of a poison that kills you or a poison that makes you sick.
Sounds like chemotherapy.
So, in other words, it's not easy.
No, it's not easy, but it doesn't get any easier. I mean, and here's the thing. Here's the good news for these areas. The Groundwater Management Act has been extremely successful in sustaining, helping the areas that it covers in sustaining their lifestyles, in growing, and having a diverse economy, in forcing people to invest in renewable water supplies, build treatment and distribution systems, you know, do the kinds of things that you need to do in order to have water security. And, you know, I know people are worried about regulation. Some people it's a nasty word, but, you know, without it,
it's the Wild West.
It's the Wild West, yeah.
You said in a blog a year or so ago that we have 2 Arizonas. Right, and that's what you were talking about?
Yeah.
The Arizona that has groundwater management, that's had most of the economic prosperity in Arizona since 1980. Right. And then the Arizona where there is no regulation at all on groundwater pumping, and many of those communities are facing new pressures related to water supply.
That's right.
Well, anything else you wanted to add, Kathy?
No, I don't think so.
It was a pretty masterful summary of the Groundwater Management Act in a very short time. It is worth spending a lot more time on, and maybe you could just talk a little bit about that moment when leadership decided that we needed to do something. I'm sure it was helpful that Cecil Andrus was holding the CAP over the heads, but
it was. But you know, he wasn't the only star on this show. Bruce Babbitt was amazing, absolutely amazing. He was the most masterful mediator that I think I've ever seen. And, you know, he brought these diverse interests together we met for over 400 hours over a 6-month period. And when people would say, well, I can't be there at 7, he'd say 5. How about 5? Honestly, we would show up at 5 o'clock in the morning, or we work at 11 o'clock at night. And Stan Turley, who was president of the Senate and a Republican, was amazing. And while he came from a ranching background, he was so open to having everybody express their views and not trying to control the dialogue. Bert Barr, the majority leader of the Senate, another Republican, as Bruce Babbitt described it, he put a wet blanket over the the members of the House and just wouldn't let them get out from under it. So it just was a different time. People coming together, and the negotiators themselves that represented the mines, cities, and agriculture willing to compromise, to hear each other's views, to come up and to really develop something that they all are really proud of.
Well, it's an inspiring example of how bipartisan effort can actually lead to really great solutions in water management in Arizona. So we have some questions that have rolled in, and I hope we're doing this, finding the questions. We might not take them right in order, but we'll start on the one that I have on my screen, which is a long one from Madeline Kaiser. Hi, Madeline. It says, given that investors are increasingly younger and embrace sustainability principles, and that a whole new industry is springing up to advise potential investors about comparative water security around the world, as a precursor to investing, shouldn't we completely overhaul our water laws to keep pace with new water management models? Aren't we tinkering with an outdated model, increasingly evident to outsiders? And yeah, perhaps this is what Sarah meant about finding new ways to resolve the general stream adjudication. And I think, Kathy, I'd love to hear your answer to that, but let me say that I wouldn't want to, I appreciate the shout out, Madeline, and I wouldn't want people to think that I want to throw our current laws out the window. I'm not that much of a radical. So in some of my private moments I might be. But Kathy, what do you think? Can we do it under our existing laws? Or do we need to just throw it all out, throw out prior appropriation, throw out beneficial use, and start over?
Oh gosh, you know, I understand the desire of some people to just say, oh, you know, this isn't working, can't we just start anew? But boy, you know, the way government works is that it's built on long-standing principles of vested water rights and certainty. And so part of the reason people are willing to make investments is that they know they have certainty in their water supplies. And it isn't really the prior appropriation doctrine that's the problem. It's the fact that we've not monitored how many certificates have been given. We haven't enforced some of the laws. We haven't really, I think we've over appropriated our supplies. And so that problem's not going to go away unless we come to grips with who has the right to use it and what are their priorities. I think continuing to handle this through the courts for the next 50 to 100 years is probably not the solution. And I think that's what Sarah's talking about.
Yeah.
Are there ways that we as a state and our stakeholders can come together to streamline this process, to make water rights more easily transferable, to get at the subflow issue, which is a huge problem, but it's not going to happen, in my view, by throwing out the baby with the bathwater. Yeah. We're going to have to take steps and work with the laws we already have in place.
Good answer. And so Jean Calhoun has asked, why not provide incentives for rainwater harvesting in urban areas to minimize new water demand? You know, I think that's very interesting. I went down and visited the Watershed Management Group Living Lab and saw their rainwater harvesting system, and it's really interesting and inspiring. In one of the issues, maybe another kind of bifurcation that we're experiencing in Arizona, is that a lot of the cities that would have the capacity to incentivize rainwater harvesting are experiencing steady annual decline in residential demand. 2 to 3% is about the average. Some are exceeding that. So I think it might be a solution, but it's not the big one. It's not the big solution, and I'm still looking for the data that shows that when people implement rainwater harvesting systems, residential demand goes down. We need to see that data before we make a big investment in it.
and actually, I think Tucson has found, the city of Tucson has found that they had an incentive program, and what they didn't find that water use went down. What they found is that people would harvest this water and then just grow more out.
Their extra water.
Yeah.
So you would need to have it tied with a demand, with a forced demand reduction. Like if you get this system, your rates go way up so that you're discouraged from treating the water. But I think one of the reasons where, as a policy matter, there isn't a big call for rainwater harvesting is that, for one thing, the big cities, other than Tucson, well, and some of them just don't get that much rain, like central Arizona cities, but also because they have this issue of extra water in the minds of the water managers, and so having more water isn't something that they're seeking, more water for which there's no demand.
This is a real individualized issue.
Yeah.
And one of the things that I learned from my long time experience with the Arizona Municipal Water Users Association is that no two cities are alike. No two private water companies or towns are alike. They all have different water supply portfolios. They all have different needs. And so they have to be able to have the flexibility to enact ordinances that will help them meet their needs.
And that also reminds me that, when I talked with the Watershed Management Group, I was really interested in how Catlow and Lisa had worked out how Tucson could really do it, to go on to rainwater harvesting and have a kind of water budget that could really, they scoped it out, they've figured the numbers out. One of the big issues in water conservation efforts is that we often have not connected the conservation to the outcome that we want. And if Phoenix adopted an aggressive incentive program for rainwater harvesting, and we all, people in Phoenix bought into it, and we used a lot less water, that would not result in flows for rivers. And so it isn't, we have to make sure that we're connecting up the conservation investment with the desired outcome. It might be highly desirable to do that, but it will not lead to the outcome that I think a lot of people on this call would want to see. The next question here is a question from Tice. What resources does the Department of Water Resources need to assist in the adjudication process? Kathy, you used to be the director of ADWR.
So, for many years now, longer than I care to remember, I have been calling for increased appropriations for the Department of Water Resources. When I was the director, I think I had about 250 employees. By 2008, the department was down to about 100 employees because of budget cuts. And what happened was that they lost a lot of key staff. They lost a lot of intellectual capacity, institutional memory, and they haven't been able to ever quite get back to where they were. So they need more money for the general stream adjudication. They absolutely do. And the good news is I can't tell you exactly how much money they need or what positions they need, but I know that DWR and the governor's office is working on that. And in fact, they will be asking for additional funds for the Department of Water Resources in the governor's budget this next year, which is great, great news. And we all should be supportive of those increases.
Mm-hmm. Yeah. Ann Durning, hi Ann, asked, what is the current status of the adjudication? That's it's kind of hard to summarize, but I would say, what would you say, Kathy? It's still, well, it's to some degree
it's bumping along, okay,
mm-hmm.
and
in fits and starts.
In fits and starts, and DWR is focused on doing some things. I know that there are some things going on in the San Pedro Basin. I am the only water attorney in the state, I think, that does not represent anybody in the general stream adjudication, so I'm probably not the best person to ask about that. But I do know that DWR has some staff people, and they are working on things, and I hope to see some progress start to happen, at least in terms of the department's efforts to classify claims and do the hydrographic surveys.
So those hydrographic surveys are the delineation of the subflow zones, and that if we were going to proceed with the litigation and not look at any alternatives to resolving it, then the idea would be get those surveys done. And one possible way to speed up the adjudication and resolve those claims might be to provide, to put more resources into both the DWR adjudication team and also into the court. Right now, the judge there's one judge in Maricopa County Superior Court assigned both general stream adjudications and a full calendar. So I think currently he has a full criminal calendar, and it's as if he's supposed to do the general stream adjudications in his ample spare time. You know, that might be a way to make things move along a little faster. This also, I can see we're running out of time, but I wanted to mention an interesting facet about water law that I first heard of from Stanley Pollock, who's the attorney representing the Navajo Nation in the adjudications. He talked in his presentation last year at the annual Arizona Water Law Conference about institutional reliance and this sort of thing in water rights cases that once someone is using water, whether or not they have a right to it, as time goes on, it gets harder and harder to totally deprive that person of that water supply. Kathy's here nodding. She's seen it. And this issue of institutional reliance, I think, is really the issue in the Upper San Pedro and the Verde. There are communities and individuals and businesses and all kinds of people who are relying on groundwater supplies for their lives and their businesses and what they do. And what we need to think about is how much more institutional reliance can we cope with, can we have? It's not only that the pumping is taking place now, it's that as we have more and more entities come in and use subflow for their prosperity and well-being, it's harder and harder to take it away from them down the line. Maybe the lawyers in the Pueblo del Sol case all agree that it might be around 2030, 2032 when the hydrographic survey for the Upper San Pedro was finally affirmed. And by then, in those years between now and then, imagine how much more pumping could be taking place in those basins. Here's another question from Tice. It looks like we have about a minute left, and I think we just have a couple more questions. If the Colorado River moves into deficit and CAP delivery cuts, will groundwater pumping begin again in the AMAs to replace the CAP supply? Kathy, short answer?
Short answer is no, except by agriculture, probably.
Okay. And that would really be in Maricopa County more than...
It'd be in Pinal County.
In Pinal County, okay. And then finally, and this is the very first question asked, can we move forward with water management if the state doesn't acknowledge that the groundwater management, the groundwater eventually becomes subflow? Oh, wow, exciting things are happening. Okay, so Kathy, you want to take that?
Well, I just want to say this. We are stuck with the system we've got right now, and I will say that when we were drafting the Groundwater Management Act, Wes Steiner, the state engineer, who was brilliant, argued passionately for connecting groundwater and surface water under one law. He was vetoed. It did not make it anywhere, and that's because we have too many uses of groundwater that were already established, and that, by the way, don't affect any surface water flows. The tie between the surface water and the groundwater was long ago severed. But we certainly can't move forward with the general stream adjudication in the San Pedro and in the Verde unless we deal with the subflow issue.
All right. Well, thank you all. We really appreciate your sticking with us and really great questions.
Thank you both. Before folks get off the line, I just want to thank Sarah and Kathy one more time. I think this presentation really underlines why we've been involved with things like advocating for funding for ADWR and things like Senate Bill 1268 and 1400 last session, and working with the planning process and ADWR going forward. I want to draw your attention to a few things. The first is tonight's showing of the documentary Killing the Colorado on the Discovery Channel. It will give you an expert-led look into the West's water issues and will feature both Arizona Senator Jeff Flake as well as Audubon's very own Jennifer Pitt, who directs our Colorado River project for National Audubon. It's showing at 9, so recommend you tune in for that. Also, the remaining webinar topics are up on the screen for you. Our next one is diversity and inclusion and conservation and advocacy. So go ahead and check out the WRAN website and sign up for those. And that's all I've got for you guys. So thank you everyone for signing up and showing up, and thank you Sarah and Kathy again.
Thank you.